Welcome to our new series, which the Miller-Johnson litigation section is going to be putting on throughout the year. We've titled it Lessons from Litigators, and we are just so pleased to have so many clients and members of our community here with us today. We've had a great turnout for this first in our series, with over 100 people, I think, registered, and many of you flowing into the room now. So we will get going without further ado. The topic for today is 10 tips for avoiding litigation and for setting yourself up for a good outcome when litigation is inevitable. I have the pleasure of introducing my colleague who is with me today, Dave Gass. He is a member and litigator at Miller-Johnson and has been practicing for over 40 years, 39 of which have been with Miller-Johnson. So Dave, thank you for being here today.
Thank you very much, Amy, and welcome everyone. We're delighted to have you here, and we're delighted to kick off this series. In the next 45 minutes to an hour, Amy and I are going to review with you what we put together as 10 tips for avoiding litigation. And if not avoiding litigation, at least putting you in a much stronger position if litigation occurs. And these tips come from experience doing this for a long time and seeing the things that should be done and can be done in terms of training and systems put in place well before there's any lawsuit. So we'll start with the first one, which is emails and the importance of emails in cases and the importance of putting systems in place or training to so your employees write emails that don't end up hurting you in court. The bottom line is emails are a critical piece of evidence in lawsuits today. Every case involves the disclosure, the production of emails by both sides. There are companies that are dedicated just to obtaining and the electronic evidence and the emails. And I can't overstate the importance of emails in lawsuits. Emails are legitimate evidence. They are often the smoking gun in a case. I would say it's not an overstatement to say the majority of cases turn on emails. And emails, it just takes a few emails that are blown up, that are read in court, that are put up on the screen, that are highlighted to make a difference in the outcome of the case. And I believe that most employees don't appreciate the fact that when they're on their typing their emails back and forth quickly, that these emails ultimately could end up being critical evidence in the case. And it's important, I think, that employees be educated on that fact and act accordingly. Every email is fair game. You don't get to pick and choose which emails you produce. If they're relevant to the issues in the case, they have to be produced. And there's so many emails that we see that are cringeworthy. And it's not that they state inaccurate things, it's that they're informal and they're often done quickly and the word choice is bad and they go beyond the facts. You see here complaints, gossip, vulgarities. They can make you look bad just on what employees say. And it only takes an email or two to make a difference in the case. And as I said, I think it is really critical that employees be educated that what they say in an email, particularly if it involves an issue that could end up in litigation, can make all the difference, and they need to act accordingly. That doesn't mean you say things that are not accurate, but you be careful. And there are some things you don't need to put in an email. And email's never truly deleted. People think they delete it, but these companies that come in, they're able to retrieve almost every email that was created. So the notion that they go away is just not accurate. So the point that needs to be emphasized to you and your employees is take great care when writing emails, both internally and externally, and make sure that they're factual and make sure that they're not speculative. There's a lot of wrong information in emails because they're cranked out quickly. And that email can come back to bite you when that email is produced in the litigation. I can't tell you how many times when you see some of these emails that you just cringe because they're wrong or they're speculative or they make you look bad. or they get into emotional issues instead of the facts. So it's critical that people are careful in what they write in an email, and that they need to appreciate the fact that emails are produced in litigation and are often critical evidence in the case. And then folks should act accordingly as they write their emails. And nowadays, that's all we do. You can't really, at least right now, you really can't go down to the office of somebody and talk about a sensitive subject. It's done by email. And so very important. And once the litigation starts, there's nothing we can do. The emails are the emails. You can't delete them, can't change them. But you can talk to your employees in advance about the importance of emails and the importance of being factual and the importance of saying things that you know to be true and not speculate or guess or say things that make you look bad. So a few other rules. So take the emotion out. If you're responding to someone internally or externally, don't do it while you're angry or upset. We don't need the emotion. It's never helpful. Try to be objective and analytical when you write an email. Don't be nasty. There's so many emails where somebody looks bad and it's not helpful. If you're in a lawsuit, to come across as somebody who's nasty, unpleasant, difficult. Don't quote someone else unless that person sees a draft. Otherwise, your quote may be incorrect. These are just some of the rules. But the overarching issue, the biggest problem as I see it, is most people do not appreciate the importance of emails to lawsuits, and they need to be educated that any email that they write, if it relates to some dispute that could result in litigation, and when I say litigation, I'm talking about employment litigation, contract litigation, products liability, any dispute that ends up in court. The emails are critical evidence, and everyone who writes an email needs to understand that. And I think that would go a long way to, if not avoiding the lawsuit, at least putting you in a stronger position if the lawsuit arises. Amy.
Thanks, Dave. And I don't know that I remembered to introduce myself, but I'm Amy Murphy. I'm a litigator. I work often with Dave Gass and enjoy it greatly. Before we move on to the next tip, which is going to be more electronic evidence, I just want to mention that to emphasize Dave's point or underscore it, I really don't have a case anymore, a litigation in any realm, contract, employment, what have you, where email isn't the most important piece of evidence in the case. That's particularly amazing in breach of contract cases, where you would think the contract is the most important document, but very often now, even when you have a contract and you're relying on it in that case, there is some email that is as important or more important than the contract. Other electronic evidence, we can touch on these briefly because what Dave just mentioned with regard to email really carries over to all of the other electronic evidence that is out there today. The main point is think before you type, convey that to your employees. Think about that yourself, especially when you're dealing with an issue that may seem urgent. It's important that our words are carefully crafted, and these various mediums for communicating with employees, communicating with competitors, communicating with suppliers, they are the sorts of media that really don't encourage thoughtfulness. We quickly send off a text. We post on LinkedIn when we're dealing with some issue. Your employees might use Skype or Slack or some sort of instant messaging service that your business employs. We see social media posts coming up quite a bit in litigation now too. All of these are fair game. They are not somehow removed from the litigation simply because they feel a little bit different than the more formal business email. And that's worth keeping in mind because it's really not the right medium for making business decisions or for dealing with litigation, or anticipated litigation. These types of evidence typically are hard to interpret or really easy to misinterpret. They are expensive to collect. Text messages in particular can be really difficult to collect in litigation, and they're often misread. So in cases that, where there's a contract and there are emails, we'll do our best to avoid having these other types of electronic documents come into the case, but they often come in now. And especially if you're dealing with whatever opposing party you're facing before the litigation even commences, if you're talking with that person over text message, those text messages are likely going to be relevant and discoverable. And same goes for the other electronic evidence that was listed in the previous slide. So the key message with tip number 2 is really the same as with tip number 1. Convey to your employees the importance of being thoughtful, even in these text messages, Slack messages, social media posts, where we, generally speaking, are a little more off the cuff. I'll take it to you, Dave.
Thank you, Amy. Tip number 3 relates to 1 and 2, and that is avoid bad writing, but it is broader than the other 2. Documents are key evidence in every case. That goes for email and the other electronic evidence, but other documents too, letters, memos, investigations. These are all things that are subject to discovery and are almost always discovered when there's litigation. And you need to write documents with that in mind. Assume every document will be read to a jury by a lawyer putting the worst spin on it, and act accordingly. And as I said earlier, documents are critical evidence in the case. And just because something's internal or marked confidential doesn't prevent disclosure. That's almost meaningless. You may think it's confidential, but that doesn't mean the lawyer on the other side doesn't get it. On the other hand, there are certain privileges, the attorney-client privilege being the most important one, that may mean a document is protected if privileged. And that privilege typically means it is communicated to your lawyer for purposes of legal advice, which is one reason you may want to get your counselor, your attorney involved early on, because if documents are directed to the lawyer for legal advice, then they would not be subject to disclosure during the litigation. It's a very strong and important protection. So,
Dave, if you don't mind me interjecting here, I just want to make one point, which is that
sure.
We say that you mark something confidential, and that's not going to prevent disclosure. And you mark something privileged, it may prevent disclosure, but only if the document actually is privileged. The point that I think is still important to get across to our clients and to those of us on this webinar who are thinking about anticipating possible litigation is that it is nonetheless helpful to your litigation team that you mark documents confidential when you think they are, and that you mark documents privileged when you think they are. Because when we get into the case and we're in discovery, we typically will enter into a protective order, which is geared toward protecting your confidential information. And one way for us to try to sort out what's confidential from what's not is at least look at how you've labeled your documents. It may not mean that the document is confidential, but we will flag it and pay particular attention to it. And certainly we will do that with privilege legends or headers or footers. So to the extent your document does have that privilege stamp or that confidential stamp, it does still help us, even if it doesn't necessarily guarantee that the document's not going to be disclosed.
Good, thank you, Amy. So in terms of avoiding bad writing, everyone needs to be sensitive that documents will be used in litigation. So people need to make a judgment. Should you write it down? We're not saying don't write things down. You need a record of what was done. There has to be a balance of writing things down that are factual to refresh your memory, but you really don't need people to write down every mistake or problem or speculation or judgment. You just need to be careful. Write down information you need and focus on the facts. And there are some things where, a meeting is more appropriate, a discussion, offline discussion. So it's a matter of being attentive, being careful, being sensitive to the fact that things you write down matter, words matter. And everyone who writes things down needs to be sensitive to the fact that the document that you create, that you generate, may ultimately be used in a lawsuit by the other side. And that sensitivity is the key thing. Being sensitive, because I believe most employees don't fully understand that, in fact, what they write down, what they think is, between them and one other person, whether it's an email or a memo, will never see the light of day. And that's simply not the fact. Amy? Thanks,
Dave. One tip I heard from a colleague of mine is when you are thinking about what to put in your notes or your meeting minutes, when something is an allegation, embrace the word allegation, embrace the word allege. Make sure that's clear so that later down the road, when someone is interpreting your notes, they don't take the statement you've made to be fact. They understand it's an allegation. All right, tip number 4 is document retention. And this is never the most blockbuster of topics. We wouldn't go to you wouldn't pay tickets to receive advice on this one. It's just not the most fun to think about, but it's becoming so important because with email and electronic repositories, we tend to carry around a lot of historical information. Businesses will routinely have email going back many, many years. They may have electronically stored documents or even documents in a physical offsite storage location going back even farther. And aside from the fact that just is costly and takes up space, both electronic and physical space, it's important to be thoughtful about what information should be kept and what information reasonably can be destroyed after a period of years. So the key with a document retention policy, which is tip number 4, is to set defensible parameters for the routine destruction of your documents, electronic and hard copy, with a reasonable retention period. Often you see a period of 7 years. But the key caveat to that is that you should never destroy documents if there's a possibility of litigation or if litigation has begun. Once you anticipate litigation, you have a duty to preserve documents. You have a duty to preserve the relevant information. So even something as innocent as forgetting to turn off your auto delete feature in your email systems could be a problem. Document destruction, advertent or inadvertent, can lead to court-issued sanctions in a case. So the moment you see the possibility of litigation, not just when you're in a case already, but when you anticipate that there might be litigation, think to yourself, this duty to preserve has now been triggered. And get your legal team involved to help you sort through which features in your systems to turn off, which document sites to harvest, where to make sure things get stored on a drive, just in case the place where they're currently stored isn't safe and secure. I cannot emphasize enough how much electronic discovery is becoming a major expense in litigation, sometimes more costly than the trial itself. So the more prepared you are in terms of having a defensible, reasonable document retention policy, the easier it will be for your legal team to come in when you have litigation and help you sort through the vast catalogs of electronic information in particular that are stored in your servers and in places you might not even realize. We're going to have a webinar later on this year that's going to focus specifically on document retention. So I'll move on to the next tip now, but please be on the lookout if you're interested in learning more about this and getting some guidance on what sorts of policies make sense and what issues to think about when you're crafting your policies. We'll have a webinar focused solely on that issue coming up later in the year.
Okay, Amy. Thanks. Next tip, meetings. It is often the subject of litigation, whether it's employment litigation or contract litigation or product liability litigation, that the subject of meetings and what happened at meetings becomes the subject of depositions and ultimately a trial. And so the point is to be sensitive about that. And you don't want to be in a position where you have disputes as to who said what and what occurred at a meeting. So there are several things you can do, one of which is to have witnesses at significant meetings so that it's not a he said, she said situation. Consider recording or videotaping, but do so openly. In other words, I wouldn't do that secretly. And by the same token, you should also be sensitive to the other side secretly recording meetings. That's a problem, and you should be aware that that could take place and act accordingly. Minutes and notes of what occurred at a meeting should be objective and factual. Again, another document that may be used ultimately in court. And if there are any agreements reached, don't have them oral, have them documented so that everybody understands, and make sure the document is accurate, no misstatements or poor wording, because the document will be what documents the agreement, and words matter. They absolutely matter. Okay, I'm going to do the next tip, which is address problems early. This is an important one. It is absolutely true that the sooner you address problems, the easier they will be to resolve. It's almost a universal truth. And there is an incentive to procrastinate, to ignore, to delay. But the longer you wait, the more expensive the issue becomes. And in terms of problems, there are really two things that need to be done. First, there needs to be a system in place to address problems. And every business is different. There could be business contract issues. There could be employment issues. There could be business practices issues. And you need to encourage all of your employees to identify them and to bring them. Some companies have an ombudsman who's in charge of that, to encourage them to report any such problems. And then secondly, address them immediately. And sometimes that requires legal counsel where there are legal issues. But I can tell you, it is much easier for the lawyers and a lot less expensive for the lawyers to help you navigate through a problem, a dispute, potential litigation early on, develop a strategy and an analysis, than it is once the train has left the station and you're in court and things have fallen apart. So the key point is identify the problems. And as I said, they may be unique to your businesses. You need to be sensitive to the types of problems that can come up. Identify them, encourage reporting of problems, address them promptly. And remember, as you're analyzing a problem, unless you have privileged communications to your lawyer, everything you say or write may be repeated in court, and you need to be sensitive to that and act accordingly. And as I said, where it's appropriate, it may make sense to get your counselor involved to help address the problem early on before it becomes much more difficult, complicated, and expensive.
Thanks, Dave. So I have the caveat to Dave's tip number 6, address problems early. That tip is correct, but with it comes another tip: sleep on hard or emotional decisions. It is a really difficult thing when you're going through either an emotional dispute or just a really hard dispute. And there are moments where in the moment you may want to make a snap decision, or you may just want to sort of nip something in the bud. Despite the fact that it is really important to address problems early and head on and be proactive, when it is a hard call, or where your emotions are involved, I always recommend sleeping on it. A hastily sent email or text message really could be costly in litigation. And so despite this earlier advice, we'd say when you're angry or upset, or when you have really struggled with the decision, just wait a day. And you may want to give us a call, give your legal team a call and talk through it. Taking those moments to step back and either think about it or not think about it for a period of time and return to it allows you to be more objective. If you are angry or upset, to sort of let that emotion subside a bit. And I think you'll end up making, substantively making a decision that will be respected and defensible if you ever do have to litigate. And you'll probably also be more thoughtful in the way you communicate that decision, which goes back to our earlier tips 1, 2, and 3 about careful, thoughtful writing that shows that you've deliberated on an issue and that conveys the facts and the decision that you've made.
Amy, let me, before you get into number 8, let me go back to 6 again, because there was one thing I wanted to mention that I did, and that is the importance of the contract. Now, a lot of lawsuits involve contract disputes, many do, and one of the things that's important, the contracts matter. And the law is the words of a contract, the language of a contract make a huge difference. That's what courts look at. So one of the things you can do early on before problems even arise is pay careful attention to the language of the contract. And we've given a number of programs, half-day type programs, going through all of the contract issues that come up and what you can put in the contract that puts you in a stronger position if a dispute arises later on over performance or breach of the contract. So that's a good example of something to do proactively early on before a problem even arises that puts you in the driver's seat in the event that a problem does arise later on.
That is a great point, Dave. And I think we see this pretty frequently at the stage of contract formation. Generally speaking, when we're forming a contract with another party, we are excited about whatever opportunity awaits us once that contract is formed. And there's a feeling of, there's agreement, there's partnership. It's important to nonetheless draft your contracts with the idea that that feeling of cooperation, of agreement, of possibly even a partnership, it may all fall apart. And it's not to be pessimistic about the situation. It's just to realize that issues can come up that complicate contractual arrangements. And the more you have done on the front end to anticipate those issues and draft to address them, the better you will be on the back end when you're facing litigation. It's hard to do that because it requires taking a more critical look at the contract and imagining the counterparties to that contract not acting the way they are acting on the day that you're forming the contract. But we would urge you to do that because that's the best way to prepare yourself for the possibility of litigation on that contract. All right, so now we're moving on to tip 8. Which is that litigation is expensive therapy. This tip is really about just pointing out some of the complications that will make it difficult for you to resolve a dispute efficiently once you're in litigation. It's not to say that you shouldn't be litigating. There are a lot of disputes that really do require litigation, require discovery, and require, depositions and the whole 9 yards. But as you are approaching an issue that looks like it's really turning into a dispute that may require litigation, consider the fact that litigation really is often expensive often slow. And so if the goal is to maintain a dialogue, a line of communication with the party with whom you have a dispute, litigation sometimes can throw a wrench into that, because you're going to have lawyers, the opposing party will have a lawyer, and the communication is likely to stop or at least slow down once you file a complaint. And then once you file a complaint, there is a whole set of court rules and procedures that we have to follow. And the case will progress in stages based on those procedures. That simply means that we're going to be on a schedule that the court will set with us. And it's usually not quick. When you have filed a complaint and the opposing party answers the complaint, possibly files a motion out of the gate, and the court resolves that motion, at that stage, the court's going to enter a scheduling order. And it's very common for the trial date, the last stage of litigation, to be 12, 15, 24 months down the road. It's important to know that going in, because you may think that you could get a quicker resolution out of court in months that are 1 or 2 months, as opposed to 15 or 24 months. Sometimes it is still helpful to file a complaint, to bring parties to the table. You can do some early mediation once a complaint is on file. But you can also do that before you even file a lawsuit. So it's just worth keeping that in mind, contacting your attorney, your litigator or legal team, and talking through the potential avenues you could take. And what is the goal? Is the goal early mediation and resolution? Is the goal that we need some discovery? So we're going to file a complaint and we're going to get into discovery as quickly as we can. Knowing sort of how long of an end goal you've got will help us craft the right strategy for you. Trial and litigation generally, and especially trial, and even depositions really carry with them an emotional toll, which is also important keeping in mind. There is a burden in just having to deal with your litigation, which will be a separate job that you're monitoring and contributing to in addition to your day job. That you hire your legal team to take on the brunt of the work and to run the case for you, but it's still going to require your factual input from time to time. It's still going to require you to prepare for a deposition, to have your IT department help us collect documents. So all of those burdens are worth keeping in mind, and we will do our very best to take as much off of your plate as we can when we're litigating. But it is nonetheless going to be at times busy, stressful, and sometimes really emotional going through litigation, even business litigation. And it's important to note, because we are still in a global pandemic, that COVID-19 continues to cause delays in litigation these days. I would say the single most difficult thing the courts are having trouble adapting to is trial. And so if your case requires a jury trial, or you are entitled to a jury trial and want one, those are just very difficult to conduct during a pandemic and keep social distancing. A lot of the other stages of litigation are moving at relatively the same pace, and courts are able to resolve motions, to hold remote hearings. Parties in a case can easily conduct remote depositions. It's a little difficult to introduce documents in those depositions, but it can be done. But when it gets to the point of trial, a remote trial is a pretty difficult thing to do. And so courts really are trying to hold those in person. And especially when you have to have a jury, that's tricky. But Dave Gass was actually involved in a civil jury trial this past year. Dave, do you have anything you want to add on that point?
Well, only that was in federal court. It was a 7-day jury trial, and we had all the COVID spacing, but a lot of courts are just not conducting them now, which is causing increased delay. That was a little unique because our federal courts here in West Michigan have been pretty aggressive about getting cases to trial, but it's still challenges. And in our state courts right now, there are no jury trials. So it has complicated things. Hopefully we get through that and over it. And we'll be back to something more normal, but we're not there yet.
One thing to consider that goes along with this tip is that the earlier you get your legal team involved, the more we can be involved in the decision whether to file, when to file, and what issues to anticipate once you've filed. I'll talk a little bit more about that at the end, but I just want to hit on it here because it's such an important point. So Dave, let's move on to tip 9.
Okay. Tip number 9 is defend baseless lawsuits. There are some cases where others are watching. And it is important that if a lawsuit is baseless, that you defend it vigorously, because if you don't, if you concede or settle, you're inviting other lawsuits. That's not true in every case. Some cases are different, but there are many cases. Employment would be a good area where others are watching, and if and they're watching to see how you conduct yourself and whether you get your checkbook out and whether you settle it. And the problem is, if you do that when there's no basis for the lawsuit, you're basically announcing to others that you're fair game and inviting potentially other lawsuits. So defending baseless lawsuits aggressively for many cases is important to send the right signals to others out there that if they bring a lawsuit, you're going to defend it and you're not going to make a settlement payment.
Okay, so that takes us to our final tip here. Involve your trusted advisors. That would include your lawyer or legal team, but it also includes other advisors that you rely on. You may have an accounting firm or a consulting firm that works with you on cases. You may have a PR team that you have to use in certain cases. When you do have those other advisors involved, make sure your lawyer or legal team is aware of it, because there are ways to structure that arrangement to ensure that, or do our best to ensure that communications among you, that outside consultant and the lawyer, are privileged. It depends on the state. It depends on the issue that you're addressing, but there are circumstances where the privilege between the attorney and the client can involve other important consultants or advisors of the company. But the main point is to involve them, because once you are litigating, the board, so to speak, has already been set. The facts are what they are. As Dave mentioned, emails say what they say. Maybe there are some errant text messages that you regret having sent. Maybe the decision was done hastily. Maybe you failed to account for some important piece of information. And those are just going to be legal issues, factual issues that come to the fore during the litigation, and we'll have to deal with them. And we will. But to the extent you involve us early, we can help you understand the facts. We can help you make decisions that are defensible in the litigation that may come about. And by doing so, we may minimize the likelihood that the case ever has to be litigated. So in short, getting us involved early when you are addressing your problems proactively will really set you up for a good outcome if litigation does ensue. I flagged this a bit earlier, but one point to consider is that when you have some issue that is turning into a full-blown dispute, if you call your legal team and get them involved, let them understand what's going on, you can do a lot of things very flexibly and efficiently before there's any litigation. one good example is, say you have a contract dispute with a party you've had a relationship with for 4 or 5 years. There may be a lot of background documents, and especially correspondence, email correspondence, that will help us understand and help you understand whether there's been a breach, whether your contractual obligation is clear, and we can analyze not only those background documents, but those emails and other correspondence to identify the best claims you may have or the best defenses you may have, which claims and defenses we expect your opposing party may raise. And doing that sets you up to make a plan for how litigation will fit into that dispute resolution process. And, we can see the facts that are going to present a problem or going to require more analysis, and talk about those facts. The earlier we do that sort of exercise, the better, because the moment you file a complaint and or file an answer and you're involved in a case, discovery starts pretty quickly, and you are already crafting the narrative or the theme that you are eventually going to want to argue to the court and potentially to a jury. And we are best able to do that if we know the facts, including the quote unquote bad facts, the facts that are not our favorable facts. The earlier we know those facts, the better we can address them. In some cases, we can even embrace them. So I can't emphasize enough how great it is when our clients get us involved to look at the law, look at the facts, and help them figure out the best way forward with a dispute.
And I would add, Amy, that it goes back to the point about doing this early, because maybe there are some bad facts. Maybe somebody did something wrong. These problems are easier to resolve early on than much later. And that type of strategizing, management, analysis early on is going to be much more useful in avoiding litigation, potentially resolving disputes, and the earlier the better.
And the earlier the more inexpensive, the more efficient. It's always more efficient and least costly if we are able to address those issues early. If you remember nothing else about the 10 tips, I think Dave and I agree the top tip is tip number 1. We have this funny graphic we found: dance like no one is watching, but email and text like it may one day be read aloud in a deposition or in court. And I know Dave and I live by that message. And it's really a good one, because there are regrettable things we all put in email or text or those other electronic pieces of evidence. Taking a little bit of time to read over something before you send it will potentially save you thousands of dollars in litigation.
Let me add to that, Amy. Just the whole point, the whole theme here is, and Amy and I have seen this so many times once we're in litigation, that things could have and should have been done differently that would have put our clients in a better, stronger position. And I don't think too many companies are sensitive to preventing lawsuits, but it can be done. It's important that it be done. The savings can be immense by taking some of the steps that Amy and I talked about, including educating employees. And there needs to be this consciousness of preventing these disputes from getting out of control, blowing up into litigation, and then having documents, emails, et cetera, that are not helpful to the position. So that type of sensitivity and consciousness by you and your employees can go a long way in saving you money and saving a lot of hassle down the road.
All right, so I am just going to mention briefly that we have an upcoming webinar as part of our Lessons from Litigators series on May 20th at 8 a.m. The no-fault law in Michigan is changing rather dramatically, and some of our lawyers in the section who practice no fault day in, day out and know it like the back of their hand are going to give a presentation on May 20th, 8 a.m. About what you need to know about that new law when you're renewing your policies. Dave, I will mention that we've only got one open comment from one of our listeners, which is that this person leaving the comment said that I always assume that any communication between two people which discusses a third person will end up in the hands of the third person, which I think is definitely the way to think about it. Do you have any comment on that?
No, I think that's good. You have to make assumptions, like the assumption that every email that's sent out will be seen by somebody else, can be used, can be blown up and highlighted, because we've seen a lot of that. And that assumption is true also. And it doesn't mean you misstate the facts, but you just act accordingly. There's ways you can word things that is sensitive to the notion that in this example given that the third party will see it. Doesn't mean you have to misstate the facts, but you can be sensitive about that. It's a good point.
I agree. All right, and with that, we have wrapped up our presentation with 15 minutes to spare, or 14 minutes to spare. Let's see, we received one question here, so bear with me. Is an employee's personal text on their own phone that may be business related able to be used against us, or personal emails? I can take that one, Dave. So the difficulty is going to be that these days your phone may be a singular device on which you are doing both personal things and business things, business emails, personal emails, and to some degree we can cordon off the personal stuff. But to the extent, for example, your work email address and your personal email address are hopefully different things, and you use them accordingly. In that case, we'll have a good argument for avoiding any personal email. But to the extent you use both, or with text messages, you may have just a single phone number from which you are texting business and personal information. In that case, it's probably going to mean that there's a collection that at least carries in that personal stuff. It doesn't mean it's going to be produced. We'll do our best to avoid it, but it is going to get collected, and it could be produced if there's a difficulty in figuring out whether that text message chain is truly all personal or business and personal. And that does come up, unfortunately, and it's not fun. So to the extent you can really separate those worlds on your single device, try to do so. I really would recommend that if you've got text message chains with your coworkers or fellow members of your company, and a lot of it is personal information about your kids, about your dog, what have you, don't use that text message to then talk about an important business decision. Give the person a call. To the extent you need to use email, you can use email, but try not to do that in text, because it does become pretty difficult to extract what's relevant to the case from what is just personal stuff. A text chain isn't easy to break up. So I think that's our only open question. And I think we've wrapped up, Dave, unless you have any final comments.
No, I think we're done. We appreciate the opportunity to present this to everyone. And if you have any follow-up questions, feel free to contact Amy or me.
Thanks, everyone. Have a good day.
Bye now.